Appeals of Tennessee is now in session.
Thank you, Ms. Lindsay, and on behalf of Judges Bennett and McBrayer, I'm pleased to welcome all three counsel to this oral argument, which we are live streaming in order to fulfill our obligation to maintain open courts. We will conduct the hearing in the same manner as if we were all together in the courtroom. The appellant has 15 minutes, and I understand he has reserved some of that time for rebuttal. And I understand two appellees will be arguing, and that they have already predetermined to divide their time by 10 minutes and 5 minutes, respectively. Unless there are any announcements, I'm asking Ms. Lindsay to call the case.
In re Conservatorship of John Bruce Wilson, Jr.
All right, the appellant's counsel has the floor.
Thank you, Your Honors. May it please the court. Your Honors, my name is Jason Havens. Our firm serves as co-counsel to appellant Bennett Gordon Scott Wilson, whom I'll refer to as the appellant or Scott. He serves as conservator for his disabled brother, John Bruce Wilson, Jr., whom I'll refer to as John or the conservatee, in this Montgomery County proceeding. I'll admit I have significantly less litigation experience than my co-counsel, Andrea McKellar, who unfortunately could not argue today due to an unavoidable scheduling conflict. However, I do have extensive experience in the trust and estates law area, and I'm board certified in Florida and Tennessee. So I hope that I can illuminate the key issues of this appeal and answer any questions that you all might have.
Well, Mr. Havens, I'm certain you will do an excellent job. I'm pleased that you've got experience in this field. I do want to confirm a few things because as I went through the briefs, it sounded like we were settling a decedent's estate, but I'm of the impression that this case arises from the conservatorship of John Jr. Is that correct?
Yes, Your Honor, it is.
And that the notice of appeal identifies the order that you're appealing from as having been entered on January the 6th of this year, which denied Scott's motion to amend. And that motion to amend sought to amend the October 1, 2020 order in the conservatorship.
Yes, Your Honor. Wherein
the judge approved the joint motion of the daughters and attorneys ad litem for John Jr. for the attorneys ad litem to enter into the mediated settlement agreement on behalf of John Jr. Is that correct?
Yes, Your Honor, that's all correct.
Very good. Then I feel so much better already. All right. Thank you.
All right. Thank you very much. As you mentioned, we are here because of those two orders. The underlying order is the one I'll refer to, the October 1st order, and the final order being the January 6, 2021 order. The sole basis of the underlying order to approve Appley's joint motion to approve the settlement agreement was, quote, pursuant to the April 24th, 2020 order modifying suspension of the in-person court proceedings and further extension of deadlines in response to the COVID-19 pandemic, and in an effort to prevent a backlog of proceedings, end quote. This erroneous underlying order and the appealed final order denying our client's motion to revise the order, as mentioned, or an alternative to alter or amend a judgment, can't be allowed to stand, as those orders deprive the appellant, our client, and John of important and valuable procedural and substantive rights. I will also quickly admit that this case is
wasn't the motion filed and your client filed a response to the motion?
Yes, Your Honor, but we were never afforded a hearing or any evidentiary process whatsoever. You also noted this was in the conservatorship, which—
Did you file a motion to take depositions or to introduce live evidence?
No, Your Honor.
All right, then how did the trial court deprive you of that?
We objected to the appellees introduced the settlement agreement, which was the first that we had heard of that or seen it anyway.
Wasn't the motion to make it as simple as possible, for the judge presiding over the conservatorship of John Jr., for that judge to determine whether the settlement agreement was in the best interest of John Jr. and whether to authorize the attorneys ad litem that the judge had appointed with the consent of Scott, for those two attorneys to sign the settlement agreement on behalf of John Jr. Wasn't as simple as that?
Ostensibly it was, Your Honor, but it's our position that this was filed intentionally in the conservatorship rather than in the estate proceeding.
It would have been wrong if they filed it in the estate proceeding, because it was to obtain the consent of the judge for the attorneys ad litem to sign a document on behalf of John Jr.
Yes, Your Honor.
The estate wouldn't have that authority.
Well, Your Honor, the estate has not actually been administered. This
Isn't that a separate, totally separate issue?
No, Your Honor, we don't believe so. The settlement agreement purports to administer the estate and trust assets altogether.
Well, but that really, in all due respect, that's a separate issue. The motion before the judge was, "Dear Judge, who is presiding over the conservatorship of John Jr., we want your permission to sign this settlement agreement on behalf of John Jr. because we believe it's in John Jr.'s best interest. And here's the facts that we believe justify this." And the judge considered that and said, "I agree, it's in John Jr.'s best interest, and you may sign the settlement agreement." The judge didn't administer the estate. The judge just said to the two attorneys ad litem, "You may sign the settlement agreement on behalf of John Jr."
But I don't think that the order even says that, Your Honor. It basically points to the COVID proceedings and the fact that there's nothing taking place in person at that moment, and has no rationale whatsoever as to why.
The motion was filed on July 15. Come the respondents, John Bruce Jr., Wilson Jr., through his attorneys ad litem, and the three daughters through their counsel, move the court for an order pursuant to Tennessee Code 34-121 to approve the settlement of all claims asserted against John Jr. on the terms set forth in the proposed settlement agreement, which is attached here too. That was the motion. Your client filed a response, and the trial judge signed an order that says, "Motion granted." What am I missing?
I think what's missing is an evaluation of whether that was in the conservatee's best interests.
The judge made that determination, so why don't we talk about that, not the administration of a decedent's estate that's not before this court? Tell me why it's not in the best interest of John Jr. for him to enter into an agreement that gives him more than he would receive under the trust.
That's incorrect, Your Honor. Under the trust, if it's carried out, which is also critical as to why.
Excuse me, I stand corrected. If that he would receive as an heir at law, not as a beneficiary. I stand corrected.
Yes, Your Honor. We would concede that that the settlement agreement does provide John Jr. more than he would receive as an heir at law. However, it does not.
Have not the federal court said the trust agreement was valid?
So, Your Honor, the federal court held a magistrate judge's report, which was adopted by the Middle District of Tennessee, held that Florida law applied to the trust, and Florida law requires formalities of a will for execution of a revocable trust in order to be valid. If that doesn't occur, the testamentary provisions in the trust document are ignored, basically held invalid. However, that does not, number one, that does not mean that the estate passes by intestacy. And number two, the federal court has no jurisdiction or power to say that. This is once the
Isn't
federal.
that why they have appellate courts? And didn't the daughters appeal that?
Yes, Your Honor. They appeal. Well, I think what was appealed was the validity of the revocable trust. There was nothing appealed in terms of how the probate proceeding was to occur, and the federal courts.
I agree. I agree. In this case, before this 3-judge panel has nothing to do with the administration of the decedent's estate.
I would argue that it does, Your Honor, because that determines to what extent the decedent's estate plan would be followed.
Doesn't this case arise out of the conservatorship for John Jr.?
Yes, Your Honor.
Isn't the judge who signed the order the judge presiding over the conservatorship of John Jr.?
Yes, Your Honor.
And the judge simply said, I find this to be in John Jr.'s best interest, and I'm allowing the 2 attorneys ad litem to sign the agreement on John Jr.'s behalf. I don't see anywhere that the judge in the conservatorship told anybody how, when, or where to distribute the estate. Where do I see that?
By approving, I think my time is up, but
you can answer the question.
Okay, yes, Your Honor.
I'll give you more time.
Yes, Your Honor.
No additional charge.
Thank you. Thank you, Your Honor. The thrust of the settlement agreement is what distributes. The settlement agreement is essentially substituting for this decedent's will and trust without either really being administered, is what's occurring, as our position.
Okay,
and that should not occur.
But what I'm looking at, and I'm still waiting for you to convince me otherwise, is that how did the judge in the conservatorship, who said, I'm approving a motion to authorize the attorneys ad litem to sign an agreement on behalf of John Jr. to settle claims asserted against John Jr., how that distributes an estate? I'm just missing that. Well, we're here from you on rebuttal, and I apologize for taking up all your time, but most of your brief talks about the estate and all the harms and fouls occurred to the state, and I'm looking at a conservatorship case. So that's my problem. All right, let's hear from the appellees.
Good afternoon, Your Honor. Aubrey Brown of the Memphis Bar. It's a pleasure to appear in front of you all this afternoon. I don't believe I've had the pleasure of appearing in front of at least 2 of y'all before, maybe Judge Bennett. But
well, don't say it's a pleasure yet. I may ruin your afternoon. So.
Well, may it please the court, I represent the appellees Deborah French, Emily Lounge, and Valerie Keaton, who are 3 of the 5 beneficiaries of the trust that has been spoken of in this case. And Your Honor, the motion that originally came before the trial court, which was a joint motion to approve a settlement agreement entered into by and between my clients, who I will refer to as the sisters, just for brevity, and John Bruce Wilson Jr. By and through his attorneys ad litem, Mr. Frank and Mr. Flom. It sprung from the federal court action. The federal court action was commenced in 2015 by my clients, where they sought in part, it was a 2-count action. They sought in count 1 a declaration as to the validity of the testamentary aspects of the trust. And in count 2, there was a count for breach of trust and breach of fiduciary duty brought against the then trustees. In July of 2018, Your Honors, the federal district court ruled that the testamentary aspects of the provisions of the trust were invalid, and that the assets of the trust should be distributed pursuant to the laws of intestacy. By this point in time, John Bruce Wilson Jr. had been appointed attorneys ad litem, Mr. Frank being one of those who was with us today. They filed a motion to reconsider. That was denied by the district court in October of 2018. And then after that, in February of 2019, the count 2 of the federal court action was dismissed. That's the count that pertained to the breach of fiduciary duty and breach of trust claims, thereby making the final judgment, the ruling of the court as to count 1, which was that the testimony aspects of the provisions of the trust were invalid and that the assets should be distributed pursuant to the laws of intestacy, making that a final judgment. John's attorneys ad litems timely filed a notice of appeal of that. And as relevant to this issue, or relevant to where we are today, the appellant did not file a notice of appeal. He did not join in or participate in the federal court appeal. In August, while the appeal was pending of 2019, there was an order entered in the conservatorship matter. And and I think this is an important thing to remember. It was an agreed order. The appellant agreed to this order. The order modified his duties as conservator and vested in John's attorneys ad litem the authority to manage and control the litigation, but also the authority to negotiate and submit directly to the court for approval any proposed terms upon which the case might be settled. And here I'm speaking of.
And the key in that order, which Scott, and I'm saying that with all due respect, because everybody, both sons have the same last name, Scott agreed to the order saying that if the court approves, we'll have 2 attorneys ad litem who will represent John Jr. in this litigation and who may pursue a settlement. But if they find a settlement that they think is in John Jr.'s best interest, they've still got to go back to the judge in John Jr.'s conservatorship to get the court approval to sign the piece of paper to make it binding as to John Jr. Is that right?
Yes, Your Honor. I mean, it was always contemplated that at the end of the day, court approval was absolutely going to be necessary with respect to any settlement that affected John Jr.
And the attorneys ad litem did that. They went back.
They did that, Your Honor. Also pertinent about that August 2019 order, the agreed order, was that it expressly reserved any rights that Mr. Wilson, that Bennett Gordon Scott Wilson, had to object to any settlement. He certainly reserved his rights to object to the court approving any settlement of that. So we, Your Honor, on July 15th of 2020, the appellees in this case filed a joint motion to approve the settlement. And without belaboring the court about all of the responses and so forth, at this point, the court entered an order granting the joint motion to approve the settlement on October 1st of 2020. And this appeal followed that. Well, the appeal actually followed the court's denial of Mr. Wilson or the appellant's motion to alter or amend that was filed after that. And so, Your Honor, there are various issues raised by the appellant in their brief. To begin with, certainly the trial court in the conservatorship action was the proper court to approve the settlement pursuant to Tennessee Code Annotated 34-1-121. And in fact, not only was it the proper court, it was the best court that was in a position to approve the settlement. This conservatorship proceeding had been pending.
Well, to be more specific, the judge presiding over the conservatorship of John Jr. merely authorized the attorneys ad litem for John Jr. to sign the settlement agreement.
Yes, Your Honor.
To enter into the settlement agreement on behalf of John Jr.
Yes, Your Honor.
Okay.
And so in turning to the appellant's arguments on appeal, in trying to discern what the main complaints are, it seems as though one of the main complaints that the appellant has is that he wasn't a party to the settlement discussions and he didn't agree to the terms of the settlement. Well, Your Honor, again, this was really essentially a settlement of the federal court appeal and the judgment, the underlying judgment in the federal court. It resolves that appeal to which the appellant was not a party. As I said earlier, he did not file a notice of appeal. He did not join in the appeal. So as parties to the appeal, the appellees have the right to dismiss that appeal, and they have a right to agree to a resolution of that as long as it does not affect the appellant's interest in the trust property. And keep in mind, we're talking about the trust property. We're not talking, I mean, it's.
Okay, but I want to come back to what's before this court. This court is not supervising the administration of the decedent's estate, the father of these 5 children.
No, Your Honor, that matter is still pending.
Simply have before us a challenge to the propriety of an order in which the judge over the conservatorship says, I find this settlement is in the best interest of John Jr., and I'm going to authorize John Jr.'s attorneys ad litem to sign the settlement agreement on behalf of John Jr. Isn't that correct?
Correct, Your Honor.
Okay.
Yes, this matter does not, the estate is not before the court. It is the appeal of the court's order granting our joint motion to approve the settlement. That is the only thing that is before the court in the context of the conservatorship. Appellant argues that complains about the court's order finding that approving the settlement agreement. He complains that it's not in John's best interest. I've made various waiver arguments throughout my brief. I know Your Honors have reviewed those, but and just to briefly touch on that, I would point out that the appellant fails to develop any argument in support of his contention that the settlement agreement was not in John's best interest. He constructs nothing more than a conclusory skeletal argument. And it's really nothing more than an attempt to relitigate the issues that were actually raised and determined in the earlier federal court case. And as far as the trial, as far as the appellant's complaint about not convening a hearing and without making findings of fact and conclusions of law, I think Your Honor's observation initially at the outset of our oral argument today that there was no request at any point in time made for a hearing or made to offer proof in this matter. So the appellant certainly waived that argument. As far as their complaint that there were no findings of fact and conclusions of law in the court's order, I would simply point out that pursuant to Tennessee Rule of Civil Procedure 52.01, findings of fact on a motion such as the one that was before the trial court in this instance were not required. Your Honor, the courts speak through their orders and judgments, and in doing so and in construing those orders and judgments, that it needs to be done with reference. They need to be interpreted in light of the context in which they were entered, as well as all other parts of the record, including the pleadings and the motions. So the court granted us the relief we requested as we requested. Court's order should be interpreted accordingly. You know, I see I'm out of time.
Thank you, Mr. Brown. Mr. Frank.
Good afternoon, Your Honors. I'm Horton Frank of the Nashville Bar, and David Flom, my partner, and I were appointed as attorneys ad litem for John Bruce Wilson in this matter. Initially, pursuant to the rules, we have adopted the legal arguments advanced by Deborah French, Meredith Lounge, and Valerie Keating in their briefs. As the court has already pointed out and noted, John is a ward of a trial court, and I struggle, frankly, with that phraseology. John is disabled by a mental illness that prevents him from making sound decisions about his health care and his business affairs or his financial affairs. And that is what the trial court is as the ultimate determiner of what is in his best interest. It's the trial court that supervises the conservator. And that's how the order that's before this court arose. The U.S. District Court judgment in this case invalidating the separate property trust was very prejudicial to John's interest. The decision resolved what would have been or reduced what would have been a roughly 1/2 interest that John would have in the rental property that's the assets of the separate property trust. And the other half interest, roughly half interest, would go to Scott, which is significant in this case because it's why we got appointed as attorneys ad litem. That interest of John of roughly 1/2 of that trust estate was reduced to about 1/5 of that trust estate. That is his intestate share. When that share is reduced, John's interest is further adversely impacted because he becomes a co-tenant in common with his sisters and his brother Scott. And because this is small parcel rental real estate in and around Clarksville, Tennessee, it can't be petitioned in kind and would have to be sold for petition, likely at a public auction. And John would wind up with 1/5 of the net proceeds of that endeavor. The point of the settlement agreement is that of all of John's siblings, he is the least able to afford this outcome, and he's the least able to relitigate the validity of the separate property trust interminably. So having perfected an appeal for John to the Sixth Circuit,
And the appeal was initiated by you and your co-counsel on behalf of John Jr. because the federal court decision was adverse to John Jr.
Exactly, Your Honor.
All right.
And we perfected that appeal. And at the Sixth Circuit U.S. Court of Appeals, we had the opportunity to participate in a court-conducted mediation and negotiate a possible agreement to compromise and settle the issues in dispute between John and his 3 sisters who were the plaintiffs. That negotiation was in exchange for dismissal of the appeal. The attorneys ad litem sought and got at this juncture the authority of the trial court to negotiate that settlement and come back. And that's what the agreed order is the subject of that was previously discussed by Mr. Brown in his argument. We successfully...
Because that appeal was dismissed, did that reaffirm the court's decision? Did that become a final judgment?
It will when it's ultimately implemented, Your Honor. That appeal has not yet been dismissed because the validity of the court's order approving the settlement agreement is on appeal. I guess you might refer to it as an informal stay. The district court judgment is already final and non-appealable as to Scott. The end product of the settlement agreement will be the adjustment of the shares of the trust estate between the sisters and John in exchange for John's dismissal of his appeal, which would make the district court judgment final as to him, but modified, if you will, by the provisions of the settlement agreement. Because effectively, the benefits of the settlement agreement are this. It ends 5 years of litigation for John, almost 6 years. And it provides the prospect, because it's front-end loaded, if you will, from the proceeds of sale, that if the property is not sold for as much as everybody hopes, John will get more than his 1/5 share. The idea was to put the proceeds of sale and anything that he gained out of it into trust with an independent trustee, and hopefully to provide sufficient principal and income to provide for him for his lifetime. And the court found those benefits and approved the agreement.
And is it fair to say that the trial judge presiding over this conservatorship simply said, I find that this settlement agreement is in John Jr.'s best interest, and I authorize Horton Frank and the other attorney ad litem to sign and enter into the settlement agreement on behalf of John Jr.? That's all this trial judge. That's all this judge did.
That's correct, Your Honor. That's correct, and we have executed the agreement, and we took it to the court because we thought under all of the circumstances, it was in John's best interest.
Okay, thank you. All right, we'll hear from the appellate. Please unmute.
Yes, thank you, Your Honor. Right, the age of Zoom, right. Thank you, Your Honor, and we would still urge the court, while we are certainly in favor of mediating and resolving disputes. That's most of what we do, especially in the trust and estate area. We would urge the court to look more closely at what is actually occurring here. As you've heard from the other counsel who said courts speak through judgments, they do indeed. And the federal court correctly, in our view, dismissed the dispositive provisions of the trust because of the way it wasn't executed properly, which was the decedent's error, an unfortunate do-it-yourself situation. We see those all the time as well. However, what they are taking as gospel and what is not at all part of the judgment, it's merely dicta, which is improper, is that this estate then would be, and the trust estate would be distributed by intestacy. That is not the province of the federal court. And what's happening here is the state court is relying on that mischaracterization to assess whether this is in John's best interest. It's our contention. It is not in our client's best interest. All of those issues have to be resolved in the estate proceeding to determine whether the decedent's trust could even be enforced through his will, whether a former will would be revived. All of those issues have to occur. And what's happening here is that they're being short-circuited and in reliance on dicta that's improper from a federal court. It's not the province of federal courts to probate estates, nor to deal with marital dissolution, as y'all know better than I do. So we would again urge the court to look more closely at what is occurring here. It is, in fact, an attempt to administer the trust and the estate through this proceeding.
Would any of the arguments you just made, though, be foreclosed in the estate case? I mean, taking as true your statement that what the federal court did went too far, overreached, that could always be argued in the state case, can it not?
Yes, Your Honor, it could, but what's occurring here is John's interest in this entire matter is being determined, and it's being determined on the basis of what has occurred in the federal litigation, which is premature.
But John Jr. appealed that adverse federal decision.
Yes, Your Honor, but only with respect to whether the trust itself, the dispositive terms of the trust itself, would be honored in that federal proceeding. That has no bearing on necessarily on a probate court, which is actually charged then with those assets which are not now passing through the probate through the trust administration. Rather, they're passing through the probate. And there is a will in effect. This decedent is testate. The opposing parties tried to file to say that the Chancery Court should actually administer this estate as intestate, and that was effectively denied because the court admitted the will to probate, the pour of a will to probate. So all those issues about what truly has to occur with respect to the property rights.
Wasn't that will a pour over into this trust?
Yes, Your Honor, but there are doctrines that allow the probate court to read into that pour over will the terms of the trust instrument, because that is the express intent of this testator, which, as you all know, and I do know this well, is the pole star of all of the construction of wills and trusts.
All right. Anything further?
No, Your Honor.
All right. Thank you. It's good to hear from all three of you and to hear your arguments, and we will take them under consideration. Ms. Lindsay.
Thank you.
I think we've lost Ms. Lindsay. Well, anyway, on her behalf, I will say that this case is recessed until tomorrow morning at 9 o'clock, and counsel, you are free to exit the meeting. Thank you.
Thank you, Your Honor.